Welcome to Business Innovators Radio, featuring industry influencers and trendsetters sharing proven strategies to help you build a better life right now.
Hey, this is Tammy Pastor, and I'm really excited to introduce you to today's guest, Zach Schorr. He is a real estate attorney and litigator in the Los Angeles area with extensive experience in the field. Mr. Schorr represents clients on a wide variety of real estate cases such as commercial lease disputes, quiet title partition, and purchase and sale contract disputes, to name a few. He's been featured on Dr. Phil, ABC's Nightline, and other media outlets to give his expert opinions on real estate law. Mr. Schorr has also been named to the Southern California Super Lawyers list for attorneys in real estate for an impressive 5 years in a row. In 2016, he was introduced in the top 100 attorneys in Southern California by Southern California Super Lawyers. Mr. Schorr is a well-recognized leader in the real estate law, and he is frequently recognized by courts and judges for his highly specialized expertise. If you ever need an attorney in any real estate disputes, Zach Schorr is your guy. Welcome, Zach.
Thank you, Tammy. It's nice to talk with you.
This is a really interesting topic because often we think about real estate transactions. It's kind of a boring situation, but when a real estate transaction goes wrong, oh my God, the sparks will fly and people can find themselves in a courtroom. So let's go ahead and talk about what are the majority of the cases that you work on?
I do a fair number of different types of cases, but I see similar fact patterns over and over. I'd say at this point in time, the most common cases that I deal with are purchase and sale disputes. Those are disputes where something goes wrong, as you said, in the purchase or sale of property, and I'm brought in to either close the sale or to avoid the sale. I do a fair number of easement disputes. Those tend to be like neighbor disputes where one side has maybe overstepped the boundaries of their property lines or is trying to acquire rights over another's property, and I represent both sides. I do a fair number of partition disputes. Those are ownership disputes amongst co-owners of land where usually somebody wants to sell, somebody doesn't, and we come in on whichever side and either try to prevent the sale or try to force the sale. And I do a sort of a catch-all area, which is quiet title disputes, and those are where we're brought in to resolve either liens on title, encumbrances on title, resolve priority of liens. It's a catch-all because it deals with just establishing legal title and who has the rights. Those are probably the most common disputes I do.
So let's go ahead and focus. I want to just talk about each one of these types of disputes because, like I said, most of the time, everything's always golden until somebody disagrees. What are common commercial lease disputes that you have litigated?
I've done a lot of commercial lease disputes. When the market was not great, and right now it's been pretty good, the most common I was doing was defaults on a commercial lease and dealing with personal guarantees. And I would typically represent a landlord and have a tenant that may be failing, and we would come in and usually we try to resolve it and figure out what they owe and over the life of the lease. When the market changed, we started to see more and more commercial lease disputes in the exclusive use provision. A lot of big commercial leases will have sort of the right to use the property like in an exclusive area, and sometimes that right will be violated, and so we'll come in to try to resolve that. An example would be a big like anchor tenant, a large national retailer may negotiate in their lease that they are the only ones that can sell coffee within 100 yards of their store, and sometimes the landlord will bring in somebody within 100 yards, and that will create problems, or vice versa.
So it could be like, okay, I'm selling coffee. You told me I could sell coffee. Now you brought in someone else. They're my competition. So that person may want to break the lease based on a fact like that. Is that something that might happen?
Yeah, probably the best example I could give is one I actually did, which was I was representing a franchisee of Cold Stone. They sell ice cream, and this was out in the Valley area of Southern California. And they had a provision in there that they were the only one within their shopping center that had the right to sell ice cream or frozen yogurt and things of that nature. And the landlord put in right next door to them a sort of a knockoff to one of the yogurt type stores, frozen yogurt. And so we ultimately had to sue the landlord to force them to stop the next door neighbor tenant from selling frozen yogurt because it was negatively affecting the Cold Stone franchisee's business. And because what was happening is they would get long lines out the door, and then when people saw that, the customers would just go next door to the yogurt shop. So we were successful and able to shut down or at least limit what the yogurt shop was selling so that they weren't competing.
You mentioned something earlier about obviously you're a litigator, but at what point do you try to resolve these issues, I guess, outside of court, I guess, and mediate them? What is the line in the sand when you say, sorry, we're going to court to solve this? For example, in your case with the ice cream versus frozen yogurt, were you able to solve that in a mediation, or did you actually have to go to court?
Both is the answer. So a good attorney will always try to resolve cases outside of court, and I think you sort of always have to be simultaneously pursuing that. It's one thing to be aggressive in court, but there's a lot of uncertainty in court, and you're ultimately left at the whim of the trier of fact. So in that ice cream case, we'll call it, there was a good attorney on the other side and a friendly attorney, which is always welcomed in my book. We did have to file a lawsuit, but they contacted us early on about mediating the case. And so we ultimately resolved it outside of court by getting the landlord to comply with our demands. And so that was a good early resolution, which is what we're always trying to get because it saves the client's money, gets some certainty, and hopefully resolves the problem, of course.
Well, I think that's really an important issue because it saved the client money. So that says I, as the attorney, I'm looking out for you in more ways than one. It's about resolving this in the best possible outcome while saving your financial resources. Let's go ahead and tell me a little bit more about what it means to quiet a title, and maybe tell me a story about an example of quieting a title.
Sure. So quieting title, as I said earlier, is like a catch-all term for dealing with, you're basically going to the court and saying, Your Honor, there's various different claims to either priority or liens on title, and we are asking you for a declaration as to who really owns title and what the priorities are. A lot of times you're doing that because the title company, whenever you sell property or you get a loan on property, everybody wants title insurance. That's insurance that you have good title. And the title insurance companies, when they issue their preliminary reports, they issue exceptions to their title policy, meaning things that they won't cover. And through that, you learn, there's problems with an old lien from 50 years ago, and we're not going to insure around that. And they say the only way we're going to provide insurance and remove that is if you go to court and get the judge to say that that lien is no longer valid. So to answer your question with respect to a specific example, I had to foreclose on a property for a client who had a judgment lien, meaning they had a judgment. The judgment debtor, the person they got their judgment against, didn't pay, and like 20 or 30 years passed, obviously before my time, and it was time to collect on this judgment. So we did foreclose on it, meaning we sold the property to satisfy the judgment, and through that, there was 2 liens that were senior, meaning they were still on title, and the title company wouldn't remove them from their insurance report. And so what we had to do is file a lawsuit against the 2 lien holders, which happened to be banks, that one had gone out of business, and I think one had been sort of subsumed by another bank, saying, look, you have this old lien on title. We believe it's been repaid. Here's our evidence that shows that the lien has actually been repaid. We can't get you to remove it. All they needed to do to remove the lien was to reconvey their deed of trust, meaning execute a document that could be taken to the county recorder's office to remove the lien. But they didn't do that. So we sued them, and then we ultimately had the court declare that the lien was invalid so that we had clear title. Hopefully that all makes sense.
Yeah, that makes perfect sense. And obviously the beauty of having a real estate attorney and litigator is that we don't have to understand it 100% as long as you do. So I really think that's important. So when you're dealing with purchase and sale contract disputes, what are some of the common types of issues that will come up?
The most frequent case we get is a specific performance case, which is a case where somebody is trying to force through the sale of a property because the seller is refusing to go through with it. So what happens is, buyer and seller enter into an agreement to buy or sell property. You go into escrow and something happens, right? It doesn't go right. The deal goes sideways. And either typically what happens is the seller doesn't want to sell or the buyer's not performing. But if the buyer still wants the property, they will typically sue for specific performance, which is a equitable decree or from the court where you're asking the judge to order that the buyer's asking the judge to order that the property be sold to them. And we'll come in on both sides of these cases and either help the buyer to force the sale to go through, or we'll come through on behalf of the seller and try to negate the sale by showing typically that the buyer didn't perform or there's some technical defect that prevents them from being able to purchase the property.
That's really interesting. I'm really, really curious on when you were featured on Dr. Phil, what were you giving your expert real estate advice on?
Adverse possession, which is this strange concept that most people haven't heard of, and that is it's like a law school exam type legal concept. But I was talking about that concept. I've since tried cases on that and used it, and I think I'm one of the few attorneys that's actually gone to trial on an adverse possession case. And it's this legal concept, and it's somewhat counterintuitive to most people, that if you sort of treat property as your own, pay the taxes, declare to the world in certain ways that the property is yours, even though it isn't actually yours, then you can obtain title to it by satisfying these certain elements. And so what I was on the Dr. Phil show to discuss is Dr. Phil asked me to come on and discuss somebody that I think was in Colorado was recording adverse possession deeds and claiming that they had taken over control and ownership, legal ownership of one of the guests on the show's property in Colorado. And what they had done is they had recorded things in the county recorder's office that had put encumbrances or bad liens on the title. And so this is one of those quiet title type of cases where someone could come in and would have to clean that up. But what they were doing was they were recording these sort of bogus adverse possession deeds, which didn't make any sense. And so I was on the show to discuss what adverse possession is and how it works.
So after you were on Dr. Phil, do you know if his guest was able to get all of that adverse possession removed so that that person couldn't make that claim anymore?
Not 100% sure, but I'm pretty sure. I have a vague recollection of a email, this is a number of years ago, about that, but I don't want to. I'm sure it was resolved in their way, right, because there's no way it would stand, because they didn't satisfy. I mean, every state has different rules. In California, there's 5 basic elements, and these people clearly, the people claiming title via adverse possession clearly hadn't satisfied them. Like in California, you have to pay the property taxes. So this was just sort of a criminal act. They weren't actually paying property taxes or anything like that. So they're hard elements to satisfy. I've successfully adversely, not for myself, but for a client, successfully adversely possessed property. But it was a tough thing, and it was through a long trial that I was able to do that. So for a client.
I think that adverse possession, I remember it was in the news quite a bit in Florida during the period of time when there were so many foreclosures and empty houses, and people would move in to these houses and take over, because the owners lived up north and everything. So I haven't seen it much recently.
It's like a legally justified squatting, but the history of it, and I've studied this at great length, is it kind of goes back to like the Wild West, where there's vacant land, and with the vacant land, as a society, we like to make sure that land is taken care of. And so if you can imagine in the 1800s that in the West is all this vacant land, and somebody owns land that they never visit, they don't pay the property taxes on, they don't maintain it, and someone else comes along and maintains it, pays the property tax, puts a fence around it, declares to the world that it's theirs, and actually sort of betters the land, then we sort of reward them by saying, after 5 years of doing this, it's yours, because the owner abandoned it, essentially.
Yeah, well, I can understand that in the Wild West days. What was the appearance on ABC's Nightline? What was involved in that appearance?
I was brought on to talk about another weird situation, but that one they had a situation with I think it was a nanny of a family who wouldn't leave the house, and she was claiming that she was a tenant and had some extended rights to stay there. And they were trying to figure out a way that they could get rid of this nanny who wouldn't leave, basically, was the story. And so I came on the show and talked briefly about sort of evictions, which we do from time to time here. And, the California prohibits self-help, so that means you can't just change the locks on somebody. And I started to identify as well this idea of a lodger, and this is more relevant to now with Airbnb, VRBO, and some of the transient rental situations where you can use lodger status to evict tenants and allow you to have some self-help. So I was on the show to talk about sort of tenant rights and this unique situation where his family was living with his nanny but couldn't just throw her out without going to court.
Wow, it just seems like we live in this world where there's just so many angles and nuances. I mean, I have had situations where I had tenants who just quit paying the rent, and of course you have to go through this entire process to get them evicted and everything. And what would your advice be to people when they are, for example, getting ready to either purchase or sell a property? Because most often, in my experience, people use the contract provided by the Board of Realtors or from their real estate agent. Is that a smart idea, or should you always go to a real estate attorney first before you get to the point where they would want to litigate?
I think that the contract that is put out in California is put out by the California Association of Realtors. I think it's actually a pretty good contract, and I litigate it all the time, and I help people on their transactions with it from time to time too. I sort of customize it, and so I always recommend that you sort of use your real estate agent or your real estate broker, but consulting with an attorney, especially on a big purchase or a big sale, is always wise, because if someone came to me with the California contract, I would cross out certain provisions, and I would make recommendations regarding other provisions on how to tailor it to their particular situation. What I find some states actually, and California is not one of these states, but some states actually require an attorney to participate in the process. California doesn't. And I sort of think it's a good idea to follow the other states, because for most people, their sale or purchase of property, especially with California property values, it's like one of the biggest financial things that they're going to do in their entire life. And the idea to me that they're going to do that without consulting someone that knows the ins and outs of the contract from a legal perspective is, like, to me, very risky. So I always think it's a good idea, even if it's just an hour, to have an attorney review it, make sure everything's right, and make sure that it's lined up right. Because when I get these types of matters, I'm looking at them based on my experience of having litigated this contract or prior versions of it, 50, 100 times, and knowing, oh, I've litigated that paragraph. There's a problem with this. Let's change it to that. And so that can really save a lot of money in the long run.
Oh, I can actually, I see that, because you're looking at it not as the whole contract. You're looking at it like little sentence by sentence and the nuances of what does this word mean.
Correct, and we get into that in the disputes, and that's what, you can have a whole dispute over what one sentence in the contract means and whether or not it was complied with. So having that experience can help you to say to a client, look, let's clarify the sentence, or let's make sure this, it can be something as simple as the vesting instructions and how someone's going to take title and what name, and changes to that, and making sure that that's allowed per the contract.
Wow. That's really interesting, because I remember one time debating the difference between may and shall. Because there is a difference.
Well, there's a big difference, right?
So, very interesting. So if people are interested in finding out about your services, where can they look?
I have a website. The website address is www.schorr-law.com, and that has all my contact info. You can find out all about all the different practice areas, and you can see on the site what judges have said about me, and all the various things that we've talked about today.
Great. Well, I really appreciate all your time. Do you have any last piece of advice for anyone who is wanting more information about real estate law or litigation?
No, I do offer for all potential clients a free 30-minute consultation. So, if someone's kicking around the idea of, do I need a lawyer involved? There's no harm in calling my office. We're happy to consult with people. I like talking with people. I do it on a daily basis. And then if you do wind up looking for an attorney, for any field of law, I always feel like it makes a lot more sense to go to that highly specialized person. And it's hard to find, at least in real estate in Southern California, someone that does more real estate than me. So that's not to say there aren't other people out there, but the way I see the same cases over and over and get to know the level of the law is really a benefit to my clients.
Well, I really appreciate the time you took with me today. Thank you.
Thanks, Tammy.
Thanks for listening to Business Innovators Radio. To hear all episodes featuring leading industry influencers and trendsetters, visit us online at businessinnovatorsradio.com today.